Assalamu alaikum and welcome to the Free Legal Advice Show on British Muslim TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, the Free Legal Advice Show provides you, our viewers, the opportunity to call in and ask any questions that you have on any aspect of English law. On the show, I'm able to cover a vast, diverse range of matters. Matters ranging from immigration law matters, family law matters, criminal law matters. So whatever your legal questions are, please do feel free to get in touch. Two ways to get in touch with us. First of all, you can ring on the landline number which appears at the bottom of the screen. Alternatively, another very popular way of getting in touch is to send us a message on the mobile number which also appears at the bottom of the screen. So for live calls, please call on the landline number which appears at the bottom of the screen. And for messages, a very popular way of getting in touch, for messages, please send the messages on the mobile number, which is also there at the bottom of the screen. A couple of minor points before we get going. Sometimes during a live show, you get a question which is quite complex. Sometimes I need to look at documents before I can advise properly. Now, if it transpires that your matter is complex, or I need to look at your documents before I can advise you properly, then I'll ask you to leave your number with the control room and I'll try and call you back off air and we can have a more thorough discussion off air. If need be, I can look at your documents as well and then give you some more thorough advice. But in the vast majority of cases where callers do call in, I am able to advise live on air. And we get numerous questions on immigration law, which is fantastic. Please do keep on sending those questions in. And even before we've come on the show today, we've had a couple of questions that have come in on our mobile number already, which is fantastic. Please do keep on sending those questions in. Now, let's look at the first question that's come in. A question that relates to immigration law. And this is something that we've been asked in practice a number of times over the last few weeks. And the question is as follows. Assalamu alaikum. I've heard that the rules are changing in June 2022, whereby someone who is on the 10-year route to settlement will be able to apply for indefinite leave to remain after completing only 5 years. Please, can you explain? Now, this is something that's likely to be introduced, or the rules have been published already and they will come into force in the next month or so. And what it covers is the situation where somebody currently has a visa to live in the United Kingdom on the 10-year route to settlement. They might have overstayed, there might have been a problem with their finances, but whatever the reason is, they've ended up on this 10-year route to settlement. So these are normally people who are here with a partner who may be British, or people who've been living in the United Kingdom for a long time and they've got children and they've been placed onto the 10-year route because of their children. So a whole host of reasons why somebody might be on the 10-year route to settlement. Now, there are some changes coming in next month which will make it easier for somebody to qualify for indefinite leave to remain. They won't have to complete 10 years under the 10-year route. Now, it looks like it's only for those people who are able to switch from the 10-year route into the 5-year route to settlement. And basically, in a nutshell, the position appears to be this, that if you are able to switch from your 10-year route visa into the 5-year route visa, because you satisfy the requirements relating to income, relating to English language, relating to your legal status, etc. If you are able to switch into the 5-year route to settlement, then once you've completed 1 year in the 5-year route and a total of 5 years have been spent in the UK legally, then you would qualify for indefinite leave to remain at that stage without having to wait the full 10 years. So this is quite a surprising, quite a helpful amendment to the immigration rules, which will be coming in the next month or so. So no doubt over the coming weeks and months. In practice and on shows like this, will be asked many questions about how one can go from the 10-year route onto the 5-year route and qualify for indefinite leave to remain much quicker. Because this 10-year route is a lot of hassle for a lot of people. A lot of people want to get out of this lengthy process of qualifying for indefinite leave to remain. They want to get into the more reasonable, the quicker 5-year route. And it looks like for certain categories of people, it will be possible to apply for quicker settlement under the 5-year route. So we'll have to see how that pans out. The rule is coming in next month, I should say, in June 2022. So hopefully that answers that question. So please do keep on sending your questions in. We've got another question that's come in, and it's a family law related question. Let's have a look at that. Question is as follows. If during an informal separation, a partner has secretly bought a house for buy-to-let purpose on a sole mortgage, does the other partner have a share in that property? I.e., if a financial settlement to take place, is it possible to get a share in that property? The deposit paid towards the initial down payment for that property, the second property which has been purchased secretly, was only possible because of financial infidelity and broken negotiations. One example is unpaid child maintenance for 3 children under the age of 16. Would the court take that into account? Now, so the basic position is that I'm assuming that both parties were legally married and the relationship has now broken down. The divorce hasn't as yet taken place. So potentially anything which is acquired prior to the divorce potentially goes into the pot from which the assets would be divided between the parties. And normally the party with the children, so if it's, let's assume, for example, the wife ends up with the 3 children, and as I see it, under 16 years old, the wife is likely to get a bigger percentage of the financial settlement anyway, by virtue of the fact that she is the one who is looking after the children. So, you know, in a normal split, if the assets, if you look at it as the whole assets owned by the parties being 100%, the wife is likely to get 80% anyway because of the children living with her. And I am of the view that any other assets prior to the divorce would be taken into account by the court. Thank you for that message. Let's take our next call. Hello, Assalamu alaikum.
Assalamu alaikum.
Ji, walaikum salam.
Hello.
Hello, ji, Assalamu alaikum. Ji, thank you for calling. What's your question?
हेलो जी, मेरी आवाज, आपकी आवाज नहीं आ रही जी.
जी, आप लाइव है, लाइव ऑन एयर.
अच्छा,
अब जी, आप आपका क्वेश्चन पूछ सकते हैं जी.
हाँ जी, सवाल पूछना था ये कि वो ना मैं अकेली रहती हूँ इधर मेरी छोटी डॉटर के साथ.
जी.
तो हमने पाकिस्तान से बुलाना है किसी को ना अपने लिए, तो इधर कोई ऐसे को पूछना है, ये हो सकता है कुछ?
जी, आप पाकिस्तान से किसको बुलाना चाहते हैं?
हाँ जी.
जी, पाकिस्तान से वो किसको बुलाना चाहते हैं?
हाँ जी, हम जैसे कि अपने लिए इधर बुलाना चाहते हैं कि हमारे लुक आफ्टर, हमारे लिए इधर कोई आ जाए, हमारे
जी,
फैमिली मेंबर.
जी, फैमिली मेंबर को बुलाना चाहते हैं ना, कि आपके साथ वो रहे, आपको लुक आफ्टर करे.
हाँ जी, हाँ जी, हाँ जी, क्योंकि हम अकेली रहती है, मेरी डॉटर 8 साल की है.
जी, जी, समझ गया मैं. जी, जी. तो असल में इसमें ये है कि आप विजिट पे फैमिली मेंबर को बुला सकते हैं, विजिट वीजा पे.
जी.
मगर
जी.
वो तो परमानेंट नहीं है ना, वो सिर्फ वीजा देंगे 6 मंथ्स के लिए. और
हाँ जी.
वो 6 मंथ्स में भी पूरे 6 मंथ्स तो यहाँ नहीं रहना चाहिए. वो जब वीज़ा के लिए अप्लाई करते हैं तो वो ये बताते हैं कि हम आ रहे हैं 2 महीने के लिए, 3 महीने के लिए. सिर्फ वो विजिट की वीज़ा देते हैं.
जी
फिर और जो वीज़ा होती है ना वो डिफरेंट होती है ना, जैसे कोई शादी पे यूके में आते हैं, कोई स्टडी वीज़ा पे आते हैं, कोई काम की वीज़ा पे
हाँ
आते हैं।
जी, जैसे मेरी एज तकरीबन 52 है, तो मेरी डॉटर, हम दोनों अकेले हैं। मैं चाहती हूँ कि उनको पक्का इधर हमारे पास आ जाए, बुला लें।
जी, जी, जी। मगर ये है ना कि वो सिर्फ़ फैमिली मेंबर्स को तो विज़िट पे ही देंगे, और जो है ना शादी की वीज़ा, स्टूडेंट की वीज़ा और काम की वीज़ा, जो काम करने के लिए बिज़नेस कोई किसी को बुलाते हैं, तो वो वीज़ा पे परमानेंट मिल सकता है। मगर सिर्फ़ आपके साथ रहने के लिए आपके घर में, वो तो सिर्फ़ विज़िट वीज़ा के लिए शॉर्ट टाइम के लिए आ सकते हैं। इसमें
अच्छा
परमानेंट नहीं आ सकते। सिर्फ़ 2-3 महीने आपके साथ रह के विज़िट करके वापस जाना पड़ता है। आप जो बात करते हैं ना कि
अच्छा जी, अच्छा जी, मैं सुन रही, मुझे मैं चाहती हूँ कि आपके साथ मैं आपके थ्रू करूँ अप्लाई या कुछ बात कर सकूँ।
जी,
फिर ऑफिस में वो नंबर, किस नंबर पे राब्ता करें तो
जी,
बात हो जाएगी?
जी, आप ये करें ना कि आप अगर आपका नंबर छोड़ जाए या तो कंट्रोल रूम है ना, तो वो आपको मेरा नंबर दे देंगे, तो मैं आपके साथ बात कर लूँगा फिर थोड़ी-सी डिटेल में।
शुक्रिया,
कोई बात
शुक्रिया,
नहीं।
बहुत बहुत शुक्रिया जी।
चलो ठीक है, ओके, अल्लाह हाफ़िज़।
अच्छी
या
जी,
थैंक यू। There's a call
अच्छी, अल्लाह
regarding
हाफ़िज़।
a family member, uh, whether a family member could be sponsored to come to the UK to live with family on a more permanent basis. And what I was explaining to our viewer in Urdu was that potentially somebody could come to visit you in the United Kingdom. They could come on a visit visa, but you can't sponsor somebody to come to the UK to live with you permanently unless it's a spouse visa, potentially student visa is longer term, or a work visa. But generally speaking, there's no care visa as such. You could only call somebody to come and stay with you as a visitor for a short time. We're taking a short break. We should be back in the next couple of minutes. See you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on it, you can ring on the landline number which appears at the bottom of the screen. Alternatively, a popular way of getting in touch is to send a message on the mobile number which also appears at the bottom of the screen. Now, just before the break, we had a caller who was asking a question in relation to whether family members could join them in the United Kingdom on a permanent basis. Now, again, in practice, this is a question that we're asked quite regularly. And the problem is this: unlike many other countries, such as USA, such as Canada, etc., where it is possible to sponsor family members to come and live with you in that country, the UK doesn't have anything similar within the immigration rules. Um, European passport holders prior to Brexit were able to call their extended family members to live with them in the United Kingdom, such as their brothers, uncles, aunts, etc. But UK immigration law uh, doesn't have those kind of provisions, that kind of flexibility. So when you're looking at sponsoring a family member to come to live with you on a permanent basis, it's only quite a narrow class of people who can come under the current immigration rules. So, for example, it is possible to sponsor one's spouse, one's children to come to the United Kingdom. Now, beyond that, it is quite difficult. It wouldn't be possible to, generally speaking, sponsor parents or grandparents to come and settle with you on a permanent basis, let alone uncles and aunts, nephews and nieces, even parents and grandparents. There are significant obstacles to sponsoring them to come to the United Kingdom to live with you on a permanent basis. So, what do we have? The possibility of family members coming really is restricted to them coming as visitors to the United Kingdom. So, coming on a visit visa, now obviously the problem is a visit visa is of short duration. Although it's granted for 6 months, normally you're not meant to be staying in the United Kingdom for much more than a couple of months per visit. That's a normal visit visa as such. So it's not that easy for family members, extended family members, to come to the United Kingdom to stay with you. So what you can do is look outside the family rules, look outside the visitor rules. Now, is it possible for the person who you want to sponsor to come to the United Kingdom on a permanent basis? Is it possible for them to qualify for a visa under a different route? It may be that they can qualify as a spouse if they have a partner in the United Kingdom. It may be that they can qualify as a student. And another popular method at the moment is where somebody is sponsored to come to the United Kingdom to work. So it may be possible to come to the United Kingdom as a sponsored worker, a skilled worker. So really the family visa rules within the immigration rules don't really provide for family members to come and live with you in the United Kingdom, except for immediate family, which is really limited to spouse and children under the age of 18. If you are looking to wanting somebody else to come and stay with you, you do really have to look outside the rules to see whether they fit into any of the other rules. But I hope that answers that question. Now, another question on visit visas that's come in on our mobile number. Please do continue to send your questions in on that mobile number. And as always, to speak to me live, you can ring on the landline number. Another question relating to visit visas. And the question is, I would like to ask a question regarding a standard family visa to the United Kingdom. There is a rule that visit visa holder has to leave the country within 6 months. Can that visitor come back after 15 days and stay another 6 months? So they'd leave within the first 6 months or before the 6 months expire. They'll be out of the country for 15 days and then come back into the UK for another 6 months. What our viewer is asking is whether that is acceptable or not. So realistically, in 12 months, the visitor would be staying in the UK for 11 months and 15 days over a 12-month period. Now, interesting question. So technically, you wouldn't be breaking the rules because on one visit, you're allowed to come to the United Kingdom and stay in the United Kingdom for up to 6 months. So you'd be leaving the United Kingdom before your 6 months expired. So technically, there's no breach of the immigration rules. And certainly, there's nothing in the rules anywhere else which looks at an average, looks at, in 12 months, you can't be spending more than 6 months in the United Kingdom. So there's nothing like that. So technically, there's no breach. If you live in the UK for 5.5 months, leave for 15 days and come back again and then spend 6 months in the United Kingdom. However, the problem is this. It is a bit of an abuse of the rules. It could be that when you're re-entering the country after your 15-day absence from the UK, so you've spent 5.5 months here, you've gone out for 15 days, you're coming back, there is a problem that at the airport, if you're stopped by the immigration officer and asked about your previous stay in the United Kingdom and asked about your absence of 15 days and asked questions about how long you intend to stay here again, you could potentially run into difficulties because although you haven't breached the immigration rules as such, the immigration officer could take the view that you're not visiting the United Kingdom. You're actually living in the United Kingdom and visiting the country which you're going to, which is the country that you go to after having spent 5.5 months in the United Kingdom. So that's the problem. So although there's no technical breach, I can certainly see there being a problem on return. But let me give another example. Let's say the person does come back and when asked at the airport, how long are you coming for? If they were coming, let's say, only for another 2 weeks because there's a wedding, immigration officer would be, I think, okay with that. However, if they were to say, look, I've spent 5.5 months already, I've been out for half a month and now I'm going to spend another 5.5 months in the UK, I think that's going to set alarm bells ringing, and that's likely to result in the entry, likely for the entry into the United Kingdom at that stage to be denied. So you do need to be careful. Now, there are some nationalities which won't have a problem as such because they don't have to see an immigration officer when they come to the United Kingdom. They can use the e-gates when they come through the airport because of the passport that they have. So if that's the case, they can use their passport to get through passport control, then really there's no problem. You'd be able to get through. The problem really is with having to go up to an immigration officer and being asked questions about your previous entry and your current intentions. I think that's where the issue is. So my view is that that level of residence in the UK under a visitor route should really be avoided. And let's say somebody does say stay in the United Kingdom for 5.5 months. Ideally, when you leave the country, try and leave the country for another 5.5 to 6 months and then come back into the United Kingdom and not try and re-enter straight away. But fantastic. Hope that answers your question. We've had a number of questions coming in on visit visas today. Let's look at the next question that's coming again on visit. I think we've just touched upon that subject and that's why we've had questions coming in. Okay, next question about a visit visa and something more straightforward about sponsorship. Assalamu alaikum. I want to sponsor my brother and his wife to come to the United Kingdom on a visit visa. What do I need to do from here in order to sponsor them? What do I need to send? What documents do I need to give to them? There seems to be, even in practice at the moment, a lot of questions being asked about visitor visas. I think a lot of people do, after 2 years of COVID, where there was very little travel to the United Kingdom. I think there are a lot of people now coming to the United Kingdom on a visit visa. And what I tend to advise clients at the moment is, when you're looking at visit visas, what's easier for you as a sponsor is maybe only to do the sponsorship or get your sponsorship declaration prepared here, get your documents ready here, and send that across to your relatives who are abroad, whether it's Pakistan, India, Bangladesh, UAE, whatever it is. So get your own documentation ready here, your sponsorship declaration and your supporting documents. Get that ready and send it across to your family members. In terms of the online application that needs to be done, the visitor application online, the documents relating to your family members who are abroad that need to be submitted, let them sort that out. That's going to be more practical, that's going to be easier for you, and it's going to be cheaper for you as well. Typically, if you go to a lawyer here wanting to do the sponsorship declaration and to get the documentation ready here, that might cost you about £100. So that's reasonable. You're not spending an extortionate amount of money. Whereas if you were to instruct a lawyer here to do the whole visitor application, it would be significantly more than that. And really you have to ask yourself whether it's worth doing that when that can quite easily be done in your relative's home country. It would be much cheaper. It would be easier as well because all the documents are there. They can take the documents across to the agent or the lawyer that they're using there, and they can prepare the file there for that visitor application. If you were to try and do it from here, you'd be sending all those documents across to you. You'd be trying to work out what they all mean. And it's not easy always to try and work out what these documents mean that they send over to you. They may be land documents, income documents, savings, and the formats that they have aren't always the same as what we have here. So I always advise clients that if easier, try and get the sponsorship documentation ready from here, send that across, let your family members sort their own application and supporting documents out in their home country. So I hope that answers your question on that. As I say, at the moment, visit applications is quite popular in practice as well. We're taking a short break. Inshallah, we'll be back in the next couple of minutes. See you then. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. And as always, to get in touch by sending us a message, you can do that by sending that message to the mobile number which also appears at the bottom of the screen. So landline number to speak to me live, and the mobile number is there for messages to be sent in. Okay, we get a lot of questions on immigration law, which is fantastic. Let's go to the next question on immigration law, which has come in. And this is to do with the EU settlement scheme. And one to do with delay. We get a number of questions, unfortunately, in regarding the time it's taken for applications to be decided. Our viewer says, Assalamu alaikum. I applied under the EU settlement scheme for my parents approximately 5.5 months ago. We did the fingerprint appointment, and after that we haven't still had a decision. How long will it take? Okay, a very common question. There are certain visa categories where there is a significant delay in processing applications, and I think the EU settlement scheme is one of those visa categories. Now, it's not uncommon for certain applications to take 9 months, 10 months, 11, 12 months for a decision. In my experience, they seemed to have got slower and slower. So there is still a backlog, even though the vast majority of applications were submitted by summer 2021, when you really had a cutoff date. You had to get your applications in. So it's approaching a year since the sort of last batch of applications were submitted. And after June 2021, there have been some late applications by people who've then come to the UK later on. So there have been applications later on, but certainly there have been fewer applications coming in since then. But the problem is there is still a backlog of cases, or possibly there are less caseworkers. So in some cases, it is still taking 9 months to 12 months to get a decision. So what can you do when you're facing a decision of a delay of this nature? Your options, unfortunately, are limited. You can get in touch with the EU Settlement Scheme Contact Centre. There is a telephone number there. There is an online form that you can complete. And once you submit that, they will normally tell you what the position is. Most likely, they will say to you, if your application is stuck in the system, is still being processed, then they will say simply that your application is being processed, and they cannot give you a firm timeline in terms of what the next steps will be, whether they're going to get back in touch with you or whether they're going to make a decision on your applications. You are really, with the Home Office, when there's a delay, on most occasions you are stuck. Now, apart from that, what other options are there? You don't always get a quicker decision by going down this route. Once you contact them using your normal contact method, which is obviously for EU settlement scheme applications, the online form, it could be writing to them. So whatever the type of application it is, there's a way of contacting them. Once you've done that, if that hasn't worked, you can always look at submitting a complaint against the Home Office for the unreasonable delay. That does prompt a reply. It doesn't necessarily mean that you will get a favorable decision, but that is one option if you're tired of waiting for a decision, that you submit a complaint or about the delay. One option. The other option is that you go and see your local MP and get your local MP to contact the Home Office on your behalf. Normally, the caseworker at your MP's office will contact the Home Office. Now, not guaranteed that you're going to get a decision. You might get some kind of update. You might be told that it is still in progress. So we've got complaint as option one. Option two, using your local MP's office as option two. Let's say that doesn't work either. Option three, if there is significant delay, and normally a delay of months or a year wouldn't be classed as significant, but if there is significant delay, you could serve a pre-action protocol letter on the Home Office, basically telling the Home Office to explain what's going on, and that if the matter is not put right, if a decision is not made, then you intend to pursue the matter through the court. So you would go to the upper tribunal or the High Court and issue judicial review proceedings against them. So complaint, option one. Option two, using the office of your local MP to get involved. Option three, serving a pre-action protocol letter on the Home Office and telling the Home Office that you intend to pursue a claim for judicial review. Option four, if nothing works and if there is significant delay, and as I've said, normally a delay of 6 months to a year wouldn't be sufficient, you then pursue a judicial review application before the upper tribunal or the High Court, depending on the nature of your case. So those are the options which are open to you if you are facing significant delays in the application that you've submitted being processed. Certainly at the moment I'm dealing with an asylum matter where somebody has applied for permanent residence and they have been waiting for over 3 years without a decision, in limbo at the moment. And that certainly we're looking at these steps. So as I've said, complaint, using the services of your local MP, pre-action protocol letter, a letter saying you intend to pursue a claim, and actually when nothing happens, to submit to a judicial review application as well. So there are a number of options open to you when there is significant delay. But what you do have to understand is a delay of months, the Home Office taking 3 months, 6 months to decide an application, is not that significant as far as the Home Office is concerned. So let's just take the situation of a normal spouse application to come to the United Kingdom. So it could be a husband, a wife who's being sponsored to come to the United Kingdom. How long does that application take to be processed, where the application is made from abroad and somebody's coming to the United Kingdom to join the partner here? Even that is taking in the region at the moment of 5 to 6 months. A lot of people who've applied, they've all received emails saying the current service standard for deciding spouse applications, these are straightforward spouse applications. The current service standard for processing those applications stands at 24 weeks. That's 5.5 months. So there's going to be a significant delay even for standard applications. Now, the email that people are receiving at the moment, those who have applied for a spouse visa waiting for a decision, the email that they are receiving at the moment is that the Home Office has decided that there are other applications which are more compelling, more they have to focus on them, specifically processing visas for Ukrainian refugees, Ukrainian asylum seekers. So the Home Office has prioritized those applications. So they'll be dealing with those applications first. And that's why the knock-on effect is that there is a significant delay in processing spouse applications. So instead of having a turnaround of 12 weeks, around 3 months, we've now moved to 24 weeks, just under 6 months. Now, so if you think about it, the delay is actually much more than that, because once the online application is submitted, somebody might be coming from Pakistan, India, Bangladesh, wherever it is, they submit an online application. The first problem is booking the biometric appointment, because until the biometric appointment isn't done, the processing of the application doesn't even start. And in my experience, let me take Islamabad and Mirpur as an example. If you apply for a spouse visa where your partner is applying at one of those centers, Islamabad or Mirpur, the appointment to have the biometrics taken won't be booked for at least around 3 to 4 weeks. So that's your first delay. You aren't able to book an appointment the following week. The appointments simply are not available. So it will take around 3 to 4 weeks to book the biometric appointment. That's when the processing of the application will start. And when the processing of the application starts, the Home Office has already made it clear that our service standard for these type of applications is 24 weeks. So by the time you add the time taken to enroll biometrics and you add the time it takes the Home Office to process your application, you're into 6 to 7 months before the spouse application will be decided. So there is a significant delay for even some applications within the UK, but certainly as far as spouse applications from abroad is concerned, there is a significant delay in getting those applications processed. Your typical spouse application, which immigration lawyers deal with day in, day out, you have to set aside between 6 to 7 months before you get a decision on that. So you need a bit of patience to be able to deal with that. But I hope that answers your question. We're taking a short break. Inshallah, we'll be back in the next couple of minutes. See you then. Assalamu alaikum. Assalamu alaikum. Welcome back to the Free Legal Advice Show. I'm your host, Ilyas Bulbulia. To speak to me live on air, you can ring on the landline number which appears at the bottom of the screen. And as always, a popular way of getting in touch is to send us a message with your question on the mobile number, which is also there at the bottom of the screen. To speak to me live, the landline number, and to send us a message, a popular way of getting in touch. Please continue to send your messages in on the mobile number, which is there at the bottom of the screen. Okay, let's look at the next question that's come in. This is to do with an in-country application. Immigration question. The viewer has submitted an application and is asking about the form, that the online form which had to be completed. Question is, hi, I used form FLRFP to apply for an extension 10-year partner route, but the application is asking about the financial requirement and also about the English language requirement. Is it normal? Okay, now understand where you're coming from. You're submitting an FLRFP, and it's the 10-year route visa that you are applying for. And obviously, your understanding is, and it is correct, that on an FLRFP, under the 10-year route, there is no financial requirement that needs to be fulfilled. There is no English language requirement which needs to be fulfilled. Now, that being the case, that there is no financial requirement, there is no English language requirement, why does the form ask me or ask you about that? So it's completely understandable where you're coming from. Now, the starting point is that it's correct that on a 10-year route, You don't need to fulfill the financial requirement, and neither do you need to pass any English tests. So that position is correct. The problem is with the way the forms are designed. It still asks these questions along with a number of other questions which are irrelevant to the visa route that you are applying under. But unfortunately, the form is designed in such a way that it doesn't correctly identify that this is a 10-year route application where there is no financial requirement. Now, what the form should do is ask you whether you're FLRFP, and you can apply under the 5-year route, 10-year route, but it should ask you that, okay, you're applying under the FLRFP visa route, but which category are you applying under? Is it the 10-year route or is it the 5-year route? Because if it was designed in that way and you were applying under the 10-year route, then you've already said at the outset, I'm applying under the 10-year route. So it doesn't then need to ask you questions about finances, questions about English, because they're wholly irrelevant. On the other hand, if you are applying under the FLRFP route and you are applying not on the 10-year route, but under the 5-year route, it is possible to apply under the 5-year route in certain circumstances. Then at least you can, if you at least the questions regarding finances are relevant at that stage. The problem with the form is it doesn't differentiate, it doesn't distinguish between the two categories. That's where the problem is. So you're being asked irrelevant questions. Now, what can you do? You can't skip these questions. So even though the questions may be irrelevant, you can't skip them. You're going to have to answer the question. So look, don't give misleading information. Give them the bare minimum information that you are required to provide. So on finances, it will ask you, are you employed? And if you say you're not employed, it won't ask you any more questions. But if you are employed, give them details about your employment. So it'll ask you very basic details about the name of your employer, the address, the telephone number, the email address, when you started working there, your job title and your earnings. You might as well just provide that information, even though it's wholly irrelevant. And when they see that your income is, let's say, £15,000 a year, whatever, you don't meet the financial requirement, it's going to be ignored anyway. When it comes to the English language requirement, it'll probably ask you, have you passed the A1, A2 test in English? And you will say that you haven't, and then it'll just skip forward to the next section. So the point is, with these forms, whether it's an FLRFP form, whether it's a normal spouse extension, FLRM, whether it's a nationality form, you will come across various questions which are irrelevant to the route that you are applying under. So there might be 10, 20% of questions which are completely irrelevant. And my advice to you is, and I think there is nothing else that you can do, you can't skip these questions. My view is just answer the questions as best you can and just leave it at that. Now, a practical point I would make is that when it comes to submitted supporting documentation, you might come across the document checklist and it may say to you, oh, you've said you're employed. Send us 6 months of wage slips, 6 months of bank statements, send us an employment letter, and all that stuff. Now, if you know for sure it's irrelevant, and we do know that under the 10-year route to settlement, these questions are irrelevant, then there is no need to submit these documents because they will not be looked at anyway. And even if they're looked at, you won't be granted a visa under the 5-year route because you yourself understand that you are applying under the 10-year route. So don't go to the trouble if it's a standard FLRFP based on you all living together as a family. Don't worry about the finances. You don't need to submit documentation relating to the finances. Simply focus on that particular visa route that you are applying under. So your typical FLRFP application based on your family, you might have been an overstayer before, you're not married, you've got children who are British. So what's the application based on? It's based on your family life with your wife and your child or your children. So documentation relating to that are relevant, not documentation relating to finance. So the kind of documents that you'll be asked to provide and you should provide, your passport, your partner's passport, your marriage certificate if you're legally married, birth certificate for your child, and then documentation which proves that you are all living together as a family. So it would be correspondence received at the same address for you, correspondence received at the same address for your spouse, and it may be that there is some correspondence for your child received at the same address as well. It could be school letters, it could be doctor's letters. And if you wanted to go further, you could get a letter from the GP or the school to confirm that you are living together as a family unit. Doctor might say, yes, you visit the surgery with the child, or the school might say, yes, you attend pick and drop of the children, you attend parents' evenings, etc. So the focus on these applications, on a typical FLRFP 10-year route application, is based on your family life. And as you correctly say, it's got nothing to do with finances, and it's got nothing to do with the English requirement. So in a nutshell, do answer the question truthfully, honestly. But when it comes to documentation, my view is there's no need to provide documentation to back that up, because it's wholly irrelevant. Okay. So I hope that answers that question. As always, to speak to me live, you can ring on the landline number, and the mobile number is always there to send us a message in relation to any queries that you have. Let's look at the next question that's come in, and that relates to an asylum application. Let me read the question out, and then let's see where we get to. Hi, my sister and her husband previously applied for asylum. The application was refused approximately 3 years ago. Since then, they have submitted fresh submissions, and they are awaiting a decision on that. What's the likelihood of the fresh submissions being accepted and then being granted a visa to live in the United Kingdom? Now, again, a very common scenario in practice. Unfortunately, we do have a lot of failed asylum seekers in the United Kingdom. So when somebody makes an application for refugee status, they make an application for asylum. If that's refused, they would normally challenge that by going to the tribunal. If that's refused, they would go one step further and ask for permission to appeal. If that's turned down, you'd go one step further and ask for permission to appeal from the upper tribunal. When none of that works, and the whole process has come to an end, and there's no hope left, what is available to you? Well, realistically, there's only two options at that stage. One is to submit fresh submissions. The problem with fresh submissions is this, that they normally only succeed where there's been a change in the circumstances of the country that you cannot return to. The classic example is Afghanistan, where you have a lot of applicants whose asylum applications from Afghanistan were refused. They've been accepted, they're from Afghanistan, but the application has been refused on the basis that it was safe to return to the main cities in Afghanistan. Now that there's been a regime change, I think even the Home Office take the view that safe return is no longer possible. So, that being the case, if you submit fresh submissions, it's possible that your fresh submissions should result in a grant of refugee status, because now there has been a change of circumstances in the country that you are a national of, which the UK wanted previously to return you to. It's not possible. So that's one scenario where your fresh submissions would succeed. Another scenario is that that you have evidence now which you couldn't have submitted previously when you had the appeal before the immigration tribunal. Now, if there is compelling evidence, it could be that you could be granted refugee status, or it could be that your application could be refused and you could be granted a right of appeal. So that's another possibility. If none of that works, you really have to look outside the immigration rules to get leave to stay in the United Kingdom. That could be if you've now formed a relationship and you've got children who are British, that in itself could result in a grant of leave to remain. So that's outside the asylum process. If none of that works, and let's say you have a relationship now with a British citizen, or there's a job offer of some sort, you could always look at the possibility of leaving the country and returning with proper entry clearance. Now, you do have to be careful with that, because in certain circumstances, your overstaying can be used against you. So you could get stuck in the country from which you are applying to return to the United Kingdom. But it's a complex matter, and I would certainly advise you to seek advice from an immigration lawyer in relation to that particular question. That, unfortunately, brings us to the end of the show. Inshallah, we'll be back next week at the same time. Until then, Assalamu alaikum.